In this episode of Nyay Pathshala, we explored the sensitive and crucial topic of medical examination of a person accused of rape. We'll discuss the ethical guidelines and the legal procedure that must be followed to ensure a fair and just process for all the parties involved. Whether you are a legal professional, police officer, or simply interested in understanding the complexities of the issue, I believe this video will provide valuable insights and information. Today's topic is about decoding the complex medical examination of a person accused of rape. In 2005, the Cr.PC was amended and Section 53A of the Code of Criminal Procedure was inserted. From the point of view of an accused, Section 53 is very important because it is a vital provision in the Indian legal system which plays a crucial role in investigation related to sexual offences. Section 53A outlines the process for the medical examination of a person accused of rape, and the goal is to obtain evidence that may support or refute the charges. So let us read the full text of Section 53A, which offers a comprehensive understanding of the provision. Section 53A of Cr.PC starts with the heading Examination of Person Accused of Rape by Medical Practitioner. So the first clause states that when a person is arrested on a charge of committing an offence of rape or an attempt to commit rape, and there are reasonable grounds for believing that an examination of this person will afford evidence as to the commission of the offence, it shall be lawful for a registered medical practitioner employed in a hospital run by the government or by a local authority, and in the absence of such a practitioner within the radius of 16 kilometers from the place where the offence has been committed, by any other registered medical practitioner, who must act at the request of a police officer not below the rank of a sub-inspector, and for any person acting in good faith in his aid and under his direction, can also make a request for such an examination of the arrested person, and he may also use such force as is reasonably necessary for that examination. So far from subsection 2 of Section 53A, I will be not reading at this moment. You can look into the BIRAC. When we go into the guidelines of the which are to be followed by the medical practitioner while examining a victim of sexual assault, I will be referring to the provisions which are from subsection 2 of Section 53A. On the scope of the newly inserted Section 53A Cr.PC, the Honorable Supreme Court in the case of Krishan Kumar Malik reported in 2011 7 SCC 130 in paragraph number 44 has reiterated that after the incorporation of Section 53A in the Cr.PC with effect from 23/6/2006, it has now become necessary for the prosecution to go in for DNA test in cases of sexual assault. It is necessary because it will facilitate the prosecution to prove the case against the accused. If you recall, prior to 2006, even without the aforesaid specific provision in Cr.PC, the prosecution could have still resorted to the procedure of getting the DNA test or analysis or matching of semen of the accused with that found on the undergarments of the prosecutors to make it a foolproof case. But they did not do so. But after 2006, now it has become mandatory that in cases of sexual assault, DNA test has to be gone into, and if it is not done, then the prosecution has to face the consequences. In a 3-judge bench of the Honorable Supreme Court, it was a case of Rajendra Prahlad Rao Vashnik versus State of Maharashtra, and reported in 2019 12 SCC 406. It held that Section 53A is not mandatory. But there are subsequent judgment of the Supreme Court which says that if you don't do the follow section 53A, the accused will not be entitled for the benefit. Why section 53A is not mandatory has been discussed in this case, and it was the view of the court that there must be a reasonable ground for believing that the examination of a person will afford evidence as to the commission of an offence of rape or an attempt to commit rape. If reasonable grounds exist, then a medical examination as postulated under section 53A2 Cr.PC must be conducted, and that includes examination of the accused and description of the material taken from the person of the accused for DNA profiling. If you looked at it from another point of view, if there are reasonable grounds for believing that an examination of the accused will not afford evidence as to the commission of an offence, it is quite unlikely that a charge sheet would even be filed against the accused for committing an offence of rape or attempt to rape. Similarly, when you talk about section 164 of the Cr.PC, under section 164 it also requires, wherever possible, for the medical examination of a victim of rape. But we must remember that the consent of a victim is necessary, and the person conducting the examination must be competent to medically examine the victim. One of the requirements of the medical examination is an examination of the victim and description of material taken from the person of the woman for DNA profiling. The Supreme Court in this case, after stating that section 53A is not mandatory, but in paragraph 54 of the said decision, the Supreme Court observed that the failure of the prosecution to produce DNA evidence will warrant an adverse inference to be drawn. In paragraph 54 of Rajendra Prahlad Rao Vasnik versus State of Maharashtra, the Supreme Court observed that for the prosecution to decline to produce DNA evidence would be a little unfortunate, particularly when the facility of DNA profiling is available in the country. The prosecution would be advised to take advantage of these facilities, particularly in view of the provisions of section 53A and section 164A Cr.PC, which also has been inserted in 2005. The Supreme Court did not go to the extent of suggesting that if there is no DNA profiling, the prosecution case cannot be proved. But the court is of the view that where DNA profiling has not been done, or it is held back from the trial court, then definitely an adverse inference would follow for the prosecution. We must remember that while section 53A enables the medical examination of a person accused of rape, likewise section 164A of the Cr.PC also enables medical examination of the victim of rape. But both section 53A and 164A are somewhat similar and can be said approximately to be a mirror image of each other. But we must remember that there are three distinguishing features between section 53A and section 164A. The first point we must remember is that section 164A requires the prior consent of the woman who is the victim of rape. Alternatively, the consent of a person competent to give such consent on her behalf should have been obtained before subjecting the victim to medical examination. But whereas in case of section 53A, it does not talk about any such consent from the accused. The second distinction we must remember is that section 164A requires the report of the medical practitioner to contain, among other things, the general mental condition of the woman. And this is not required in section 53A when the accused of person of rape is examined. The third distinction is that under section 164A subsection 1, the medical examination by a registered medical practitioner is mandatory when it is proposed to get the person of the woman examined by a medical expert during the course of investigation. If you read that 164A, then you will find that this has come out by the use of the words "such examination shall be conducted," quote unquote, "such examination shall be conducted." Whereas if you look at section 53A, it merely makes it lawful for a registered medical practitioner to make an examination of the arrested person. Well, if there are reasonable grounds for believing that an examination of the person will afford evidence as to the commission of such offence. In cases, you may imagine those cases where the victim of rape is alive and is in a position to testify in court, then it is possible for the prosecution to take a chance by not medically examining the accused. But imagine those cases where the victim is dead and the offence is sought to be established only by circumstantial evidence. Then in those cases, medical evidence assumes great importance. For the failure of the prosecution to produce such evidence, despite there being no obstacle from the accused or anyone, will certainly create a gaping hole in the case of the prosecution and give rise to a serious doubt on the case of the prosecution. The courts have constantly observed that it doesn't want to go into the question whether section 53 is mandatory or not. But section 53A, we must remember, enables the prosecution to obtain a significant piece of evidence to prove the charge. And if the prosecution fails to do the medical examination, it is certainly fatal to the prosecution case, especially when the ocular evidence is found to be not trustworthy. The next question, which definitely comes to our mind, that is medical examination of an accused under section 53A of CR.PC is compulsory. You may look into the judgment of Siva Vallabh Nyay versus State of Karnataka reported in 2015 to SCC, page 90. In that case, the Honorable Court has said that yes, section 53A may not be mandatory. But if you look into the gist of the judgment, you will find that the court has said that the accused should cooperate with the investigation. And if for some reason 53A there is no time limit when it has to be recorded by the investigation. It can be recorded at the beginning of the investigation at the earliest possible of time, or it can be recorded at a later stage also. But if you don't record this, you don't allow yourself to be examined under section 53A Cr.PC, the accused may lose the right of taking the defense of delayed recording of delayed examination of the accused medically as per section 53A. In many of the cases of rape, if the doctor or the medical practitioner doesn't properly examine the accused, then it becomes difficult to prove the commission of rape in some of the cases during trial. So I have formulated a guideline for medical examination of a person accused of rape. This may be helpful for a medical practitioner as well as it may be helpful for the lawyers during cross-examination. The first point that the medical examiner should remember, the purpose of the examination. He should first understand that this medical examination of a victim of sexual assault aims to collect evidence related to the alleged rape. Then he should look at section 53A as well as 164A, that whether he is a registered medical practitioner authorized to conduct the examination as enumerated under section 53A of the Cr.PC. Number 3, the medical practitioner should verify that the examination under section 53A has been requested by a police officer whose rank is not below the rank of a sub-inspector, and for any person acting in good faith in his aid and under his direction can also apply. The medical practitioner can also seek informed consent from the accused for the examination. And the entire details has to be documented. Say for example, he should record the name and address of the accused. He must also look into the document where the name of the person who brought the accused is incorporated. He should note the age of the accused. Then the next stage comes is for assessment of injury. The doctor or the medical practitioner should examine the accused for any marks or injuries on his body. And if injuries are found, then he must locate the position and he must record it, and he must also explain the injuries, the nature of the injuries. Then there are certain evidence which has to be sent for laboratory examination. While collecting this material collections, he should first collect materials from the person for DNA profiling if it is required. And while collecting this material particulars, he should maintain a clear chain of custody for any collected materials which relates to the handling of evidence. After all these steps have been complied with, then he should prepare a comprehensive report. And what the report should include? It should include the accused's personal details, injury or marks found during the examination, description of materials collected for DNA profiling, any other relevant particulars which he thinks that is relevant. Then he should draw up the conclusion. While drawing up the conclusion, he should clearly state the reason for each conclusion reached during the examination. And in the report, he should also reflect the exact time when the examination commenced and when it was completed. Once the report is prepared, he should promptly send this examination report to the investigating officer. He should ensure that the investigation officer includes the reports as per the documents submitted to the magistrate under the provisions of section 173 Cr.PC. These guidelines are essential for medical practitioners who conduct examination of individual accused of rape, because it will ensure a thorough and legally sound process while preserving the integrity of evidence. I will request the viewers to see some of the judgment. I am giving the citation in your screen. You can look into it. One is Prakash Nishad alias Kewat Jinak Nishad versus State of Maharashtra. It is reported in 2023. You may charges. The next is Virender versus State of MP 2022 8 SCC 668. Next is Chotkau versus State of UP 2022 SCC online 1313. And this provision of section 53A is constitutionally was also challenged before the Karnataka High Court. And the Karnataka High Court has upheld the constitutional validity of section 53A. You may also refer to the judgment of this Karnataka High Court, which is Shankaracharya versus State of Karnataka 2014 SCC online Karnataka 5639. The provisions of section 53A of the Cr.PC underscore the importance of due process and meticulous documentation in criminal investigation, and particularly those concerning sexual offences. The correct application of this section will ensure the integrity of the evidence collected, and it will also contribute to fair and just legal process. The guidelines that which we have discussed in this video emphasize that any lapse in following this procedure can significantly impact the outcome of a case, and it may even lead to the reversal of a conviction. So remember that it is crucial for law enforcement agencies like police and medical practitioner to adhere to the guidelines set by section 53A. They must maintain the chain of custody and expediently conduct examination of the accused under section 53A to ensure justice. We all must remember that a criminal trial is but a quest for truth, and the nature of inquiry and evidence required will always depend on the facts of each case. The law says or presume that a person is presumed to be innocent until proved guilty in accordance with law. And this presumption of innocence will have to be balanced with the rights of the victims and above all the societal interest for preservation of the rule of law. If you found this information valuable and would like to stay updated on legal matters and important topics, I would request you, please subscribe to our channel, because it is your support which will enable us to continue providing educational content on critical legal issues. Thank you for being a part of Nyay Pathshala, where we aim to promote justice, knowledge and understanding. So subscribe now to stay informed and engaged.